Okay, I'm Alice Paylor, and with me is Margaret Seymour, and we've been asked to come give an orientation on parliamentary procedures and running board meetings and that type of thing. Because I'm one of the oldest people around, I thought I would just start out and give you a little history of Charleston County School District, 5 minutes worth. I started representing the district in '82, and the first thing that we had to do was defend a school desegregation case. And that arose out of the creation of the district in 1967. And really what that case established was the Charleston County School District was created out of the 9 former districts into one. And the purpose of that creation was to equalize funding throughout the district, because there were so many poor areas that didn't have any commercial properties and real properties that created that. So that's what actually happened, and it ended up creating a much larger district with much more resources to provide services for students. So I did want to remind all of you that there is an act. It's called Act 340 of 1967, and that governs this school district. It's been amended numerous times. The last time it was amended was to change the voting to single member districts, which I know you're all familiar with, but that was actually local legislation that was enacted so that to change the way that the members of the school district were elected. Because before that, it was based on the former school districts, which became constituent districts. So all of that came about then. So I did just want to mention that so you'd know that if anybody ever did refer to Act 340, that's what they're talking about, because it does create this board, and it creates the Charleston County School District as a body politic and corporate, which means that the district itself can sue and be sued. It is a legal entity. The board is the governing body of the legal entity. So as board members, when you come together and you have a quorum and you make decisions, that becomes policy for the district. And that's how you govern the district, is by creating policies. I was just going to go through some of the board policies, and if anybody has a question, interrupt me. And then I'm going to have my friend Margaret Seymour talk about Robert's rules and the parliamentary procedure and that type of thing. And I will tell you that I have run meetings before, and what I got was this little cheat sheet. I know we all, when you went to school and you wanted to get the skinny, you bought one of these. So I bought several, and I gave one to the chair here, and I'm going to give one to Ms. Watley also. So she has one since she's running a big meeting. And I know Ms. Bailey, if you ever have to step into the chair's role, she'll either lend you hers or I'll get you one too.
I got one.
You got one? Okay. You're smart. You already got it. All right. So I've talked about the act of consolidation. In addition to the act of consolidation, state law has what's called Title 59, and those are the statutes that apply to education in the state of South Carolina. Not all of Title 59 applies to K through 12 education, but there are certain portions. And I will tell you that Article 19 of Title 59 sets forth statutes that apply to this board. So that's something that it may come up, and I say this is governed by 5919 whatever, like the and under other ones are like the Teacher Employment Dismissal Act is in Article 25 of Title 59. But you don't necessarily have to know what those are. I just wanted you to be aware that in addition to Act 340, Title 59 is going to have a lot of things that govern the duties and responsibilities of boards of trustees of school districts. The other state law that I think you are aware of is FOIA. And FOIA is something that we all have to be aware of. It means that if a majority of this board ever meets, that's a public meeting. And that can only be done with prior notice, and that has to be, you have to inform the public of that. And that law sets forth how that's done. And these two wonderful ladies up here, they know all about FOIA, and they make sure that your meetings comply with that. And I know last summer that the Attorney General sent a letter to this board saying that he had been made aware of some violations of FOIA, and that had to do with putting items on the agenda. So if the administration tells you that you have to follow the board policy to get items on the agenda, it's mainly so that we can be in compliance with FOIA and not get any more letters from the Attorney General's office. So I did want to remind you of that. You have board policies. Those are the B policies in the policy manual. And they give you the board's purpose. And these policies, I understand, were created with the help of the South Carolina School Board Association. Some of them have been around a pretty long time, and I would recommend that we do some tweaking of these. And I've talked to Mr. Kelly a little bit about that. Not just the B policies, but there are a lot of them that probably should be tweaked. They've been in a policy manual since the early 2000s, a lot of them without any changes. So as we know, everything changes over time. And actually that's what policy BA says. The board will regularly and systematically monitor all policies in this section and will assess the quality of each meeting by debriefing following its conclusion. BBA gives the board's powers and duties, and it discusses that the board is the policy-making body of the district. And it also provides that there is an executive branch, and that executive branch is our superintendent, and that's the person that the board appoints as the executive, and you charge that person with and hold them responsible for the operation and management of the district. And that's the person who the board should go to if they have concerns. The board is also can be a quasi-judicial entity, because you might have hearings that come to you under certain provisions of statutes. People get hearings in front of you. The primary ones are the Teacher Employment Dismissal Act, and then student disciplinary hearings can come up to you on appeals through the levels. And at that point, you're basically serving as a judge and jury in a quasi-judicial role. You do a lot of things. You provide financial resources. You appraise and approve what's going on, educational planning, visits to schools, and making sure that if you need information that it's provided to you. Policy BC sets forth the meeting protocol, and this primarily deals with civility and decorum at the meeting, and how that's to be addressed and handled, and that everyone is acting with respect and courtesy to everyone. Also talks about use of electronic devices, so you're not supposed to have your phones going off, that type of thing, which we as lawyers understand, because the judges do not like it if your phone goes off when you're in a hearing. There's a code of ethics for board members. I know you have read those and you understand those. You are here with the purpose of serving the students and the teachers and the whole community here, and to make sure that an education is being provided. You're not here for any personal gain or to get any personal benefit for any of your friends or anyone else. So, and you also need to recognize that your authority comes about from board meetings when the board makes a decision. Individual board members have no more authority than a citizen of Charleston walking. Your authority happens when you're in this boardroom, and that's why it's so important for you to be prepared when you come in, and for you to always keep in mind the best interest of Charleston County School District. You want to maintain a good relationship with the superintendent and his staff. That's very important to making sure things are run properly. Conflict of interest, and I touched on that a few minutes ago. If something comes up, say you have a sister who's a teacher and something comes up, you want to make sure that the chair knows that you have a conflict of interest and you are recusing yourself from voting on anything with regard to that. So those things can happen, and that's why we have this conflict of interest. If a contract's being presented that you have a relative who's going to benefit from, that's another time you would want to say, I have a conflict of interest and I cannot vote on this. And there are forms, I think, that are used to make sure the chair knows why you are not voting and that type of thing. The other thing that's very important is when you go into executive session and you receive confidential information, I just want to remind all of you how important it is not to share that information outside of that room. And that's given to you in confidence as a board member. And the reason it's done in executive session is it's not appropriate for public disclosure. So I just want, that's one of the most important things that you've got on your plate, is to remember that you are a trustee of the district and you are given information that members of the public are not given. And there's a reason why it's coming to you, because you are an elected representative and not just somebody walking down the street. Okay. And so I do want to impress upon you how important that is. We've already got our board officers.
Ask a question.
Sure.
You touched on executive session, and I know there have been numerous articles in the newspaper recently. What governs executive session legally for our school board?
What items should be executive session? Okay. The easy one is if you're receiving a legal briefing, because all matters, when you're getting a legal briefing, that's covered under attorney-client privilege.
Okay.
So it's confidential. If I'm the one giving it to you, I cannot tell anybody, I would not tell anybody except people in the need to know, as far as if it's a court case and we're trying to settle something, that type of thing. And you never take action in executive session. Everything has to be taken in public. So, for example, if I came to you and I said, we're negotiating a settlement in a case and we'd like authority over what the superintendent has, and it goes up to the board. And you don't vote on that in executive session. And you also don't want to vote on the amount outside of executive session, because then the other side's going to know, so it cuts into negotiations. So what you would probably do, or what you would do in that situation, is come out and make a motion to approve authority to general counsel to negotiate a settlement, and you don't put the amount in there, but we will understand what it is, because you also don't want to undermine your ability, which goes to the confidence of it, because you shouldn't tell anybody when you come out either. So it kind of goes both ways. Other things that are discussed are personnel issues. And most personnel matters are confidential when you're talking about them, and not something that should be in the newspaper or discussed in public. So those matters might come to you during that time also. Contractual, and I'll give you another example. So if the district is negotiating to buy a piece of property or to sell a piece of property, Mr. Baroe might come in and ask for authority up to, to do those negotiations. So that's another one that's very similar to what I was talking about with the attorney-client, but you don't want to give away what you're going to do in that type of thing. So I think those are things that would normally go to executive session. Also, anything involving a juvenile. Since anybody under the age of 18, those, their names are not to be disclosed in the public session. So that's another thing that you would take up. So when you take up student disciplinary matters, for example, you do that in executive session. And when you come out, you also don't use the name of the student when you make your motion. So it's just protecting things to which you have a right to privacy and other people have a right to privacy on. That's kind of the how it gets there. And most of those you're going to know ahead of time, so they'll be on the agenda. They have to be on the agenda in order to go into executive session. Did I
Yes.
do it?
And my only other question, heaven forbid this were to ever to happen, but what if someone brings something up and they kind of take a caveat with an agenda item, and then you see where it's going?
You can caution them and say that should be an executive session item. And if you don't have it on there, then you might have to put it on the next meeting. I know there's also a board policy where if it's an emergency, then I think 2/3 vote is needed to add it to the agenda. And, and you could have an emergency, say, you had a fire somewhere and you got to really take some quick action and you want to negotiate a contract or something, then hopefully you got 24 hours, but there is a policy that if you have an emergency, you can put things on the agenda without going through FOIA, but that is allowed under FOIA. So that's another thing, but that's kind of, one of the jobs of the chair is to pick up on that. And if it seems like something's going to be discussed that's really not like a student's name or something, you want to cut it off while you can. You've got committees, and I think you know how those work. We have the committee of the whole, which is the entire board, and so that's also always covered there. These are always covered by FOIA, and it's a public meeting. So, and Margaret's going to talk a little bit more about those when she gets to the parliamentary procedures. Because it is, the only action can be taken in a board meeting. So the committee of the whole, you can make recommendations to go on the board, but you don't vote on the items at that meeting. Board meetings, you know what they are. You understand that how it works with the second and fourth Mondays of the month. And you have public participation, public comment. Everything is in here in the latest edition of Robert's Rules of Orders, which is not a law. I want to make sure you understand that. That's not a law. This is a guide to help meetings run smoothly. So there's not a parliamentary law. It's basically a guide. We talked about the agenda and the notice and the policies require 2 readings. So if there is going to be an amendment of a policy, it does require 2 readings at the board level. And I'm going to turn it over to Margaret to talk about Robert's rules and how that works.
All right, thank you. Good afternoon, everybody. A lot has been said about Robert's Rules of Order, and it's just a procedure that explains the general parliamentary procedures. And a parliamentarian would be a person who's an expert in interpreting and applying the rules of order. But the parliamentarian, if in a meeting, does not rule. Parliamentary law or procedures gives to the chair the power to rule on questions of order and on proper application of the rules. The role of a parliamentarian in a meeting is purely an advisory role and a consultative role. It helps the presiding officer in a meeting respond to points of order and parliamentary questions. You can compare parliamentary procedures to the rules of the road. For example, when everyone knows the parliamentary rules, meetings run more smoothly and there are no head-on collisions if everybody's on the same page with regard to the rules. And collisions can be prevented if you follow the rules. So what is it and why do we need them and why do we want to follow these rules? It would enable an organization to take care of business in an efficient manner, and it helps the organization maintain order. It ensures that everyone gets the right to speak and everyone gets the chance to vote. And it allows for business to be taken up one item at a time. And so there's less confusion if you follow these rules. It promotes courtesy, it promotes justice, and it promotes impartiality, and ensures that the rule of the majority, while it also protects the minority and any absent members that may not be at the meeting. And there's some basic principles with regard to the parliamentary rules. As I said before, it allows the organization to take up one item at a time. Each meeting would follow an order or an agenda, and only one motion can be pending at a time. Only one member can be assigned the floor at a time, and members will take turns when speaking. No member can usually speak twice about a motion until all members have had a chance to speak on the motion. The rules also promote courtesy, justice, and impartiality and equality. In doing so, the chair will call the meeting, the members will take their seats promptly, there's no crosstalk in a debate. The discussions are kept to the issues at hand and not to personalities. Members listen while other members are speaking, and members have the right to make a motion and to vote. It also protects the rule of the majority and protects the minority in that members have the right to have notice of all meetings. Members have the right to know by previous notice when there is a proposal to rescind or amend something that's previously adopted. And also, when members' rights are taken away, 2/3 of the membership must approve that, and members have a right to be informed of the work of the organization. In this, organization, we have the committee of a whole, and that enables the full board to give detailed consideration to a matter when it goes into discussed by the committee as a whole. Any action by the committee of a whole as a whole are not decisions of the board and are recommendations of that committee to the whole board. Votes taken are not final decisions, they're recommendations, and which the board is given the opportunity to consider and vote on. When the committee as a whole votes, members cannot reconsider the issues voted on because the votes of the committee of a whole as a whole are not binding. It is only a recommendation on which the board will vote later. No matter can advance to the board as a whole unless it has been approved by the committee as a whole, except there's certain exceptions like for the finance and audit, student procedures and discipline and matters of that nature. The agenda of the board must be in compliance with FOIA, and the superintendent prepares the agenda for the board meeting, and items for the board meeting agenda will ordinarily come from the committee as a whole. If requested by a committee or any 4 board members, an agenda item shall be placed on the agenda, and the item must be identified and described on a board action item form, and the form must be turned in before the deadline for submission of these items. And the item must be accompanied by the appropriate backup materials. Agenda items for which supporting materials have not been received in a timely manner shall be deferred to the next regularly scheduled meeting. And once an agenda item is posted, no items may be added to the agenda unless it is done at least 24 hours prior to the meeting and proper notice is given. At the point the meeting has been called to order, an item may only be added to the agenda by 2/3 vote and upon a finding by the body that an emergency will occur if the item is not added to the agenda. With regard to notice, when notice is required to be sent, unless a different standard is specified, it can be sent by postal mail or by electronic communication. Alice has already gone over the ethics and policy with regard to conflict of interest for the board, and any questions with regard to the parliamentary procedures?
I have a question.
Mm-hmm.
The parliamentarian is basically the peacekeeper, because from what I understand, a parliamentarian was added because of the actions of or behaviors of previous board members. So if legal counsel is already here and they are able to advise, do we need a parliamentarian?
You don't have to have a parliamentarian. There's no requirement of that. And there's no parliamentary law. And the truth of the matter, if you got this and you got a chance to look at, when something comes up that's a question, it'll be answerable in Robert's rules. Now, the chair may not have a chance to look and she might want to ask us. And we will always have the book's about that thick that we can look at if it's not covered in this. But, and I was telling you, I've run meetings before. I was chair of the House of Delegates for the South Carolina Bar, and I had 250 lawyers making motions and getting up and doing stuff. And they all thought they knew everything, okay? So I had to call, and the chair actually makes a ruling. And then if somebody thinks it was the wrong ruling, they can challenge it, okay? And there's a procedure for doing that. But to move things along, and that's why it's really the chair's prerogative to make the ruling on what's before. So like most of the stuff is pretty simple. If somebody makes a motion, it's got to be seconded by somebody before discussion, unless it comes from a committee. So, a lot of those things, and then you don't get a lot of the stuff at a small level like this, where somebody wants to table something. But there is a procedure that's pretty simple. So a motion to table, they rank the motions that you rule on in the order, in a certain order. Some motions take priority over others. So you would take those first and then go through, I think, a motion to table you have to take first if that comes up, because that ends all discussion and it's, done. So there's no reason for you to discuss everything if you're going to table it. But yeah, there's no parliamentary law. There's no requirement that a parliamentarian be a lawyer. There are plenty of lay people who are not lawyers who train themselves in being a parliamentarian, and they sell their services. So, but I think on the level that y'all are with 9 members, you've only got 8 now, then, you've got a very capable chair and vice chair, and, we can figure out what's going. I don't think it's an impartial decision, which is why you have Robert's rules. You just go by the rules.
So as long as we know how to act and conduct ourselves accordingly, then one is not needed.
I think y'all are gonna be fine.
I disagree with, is that I don't think that parliamentarian procedures is about acting alone and how to conduct yourself. It's about order. And I'm gonna just go back to the last meeting. And then I want to go back to address the reason you had a parliamentarian before, whether it was the board that didn't get along. I don't know any of those things to be true. I thought that it was said that it was based out of a consent, a survey that was done, a study, an equity study, and that the former chair asked for a parliamentarian based on a equity study by Clemson. So if I was misinformed from email, I think that needs to be corrected. But for me, I think it is necessary to have a parliamentarian. I think that we are all professionals and we know how to conduct ourselves in a business meeting, but it's more for order. I think the last meeting, when we spent a lot of time trying to decide if we should move on, if it was time for a vote, or if it was just a recommendation for discussion, that was very embarrassing. So it had, to me, it doesn't have anything to do with whether we are behaving, but it has to do with the flow of the meeting. And so whether it's an attorney or whether it's just a member of this board that is designating the parliamentarian to make sure everything is flowing, it's important to me for that reason. And I don't want it to be marginalized that, the matter of the business and the size of the board, it's small. It's a matter of order, and for our constituents to be able to follow, and for the public to trust that we know what we're doing. So,
This is not a
Mr. Kennedy,
decision.
if you would speak to the study that this came out of.
We don't have anything to do with whether or not you have a parliamentarian. That's not our job. If the board votes to have a parliamentarian, then they would ask the superintendent, I guess, to find one for them.
So I'm sorry, ask the question again.
Yeah, it was my understanding that the previous parliamentarian was a request of the former chair based on a Clemson equity and inclusion study that was made. Now, let me just say that It doesn't matter to me whether or not it's an attorney or we don't have one. I'm just an orderly person, and I'm just asking for clarification. Did the parliamentarian come out of an equity and inclusion
Yeah,
study?
so I don't know. I'm going through my emails now to see. I did brief the school board that in my research, I discovered that the board chair, Reverend Mack, asked the superintendent, Dr. Postaway, to acquire a parliamentarian. And that's what she did. So it was not a vote by the school board. It was a request or instruction from the board chair to the superintendent. I don't know why he did that. And it may be in the email, and I'll look at it. In fact, the first time I saw the parliamentarian was not at this board meeting. It was at the AD23 board meeting that he was requested to attend. And that was sometime, I think, slightly before the pandemic started. I know it was an in-person meeting.
Yeah, it says that a recommendation of the Clemson Equity and Inclusion Study. And so if that is true, is that study still relevant? That's what my question would be. Where is this study? And if the recommendation for a parliamentarian came out of the Clemson Equity and Inclusion Study, is that study still relevant?
Yeah, again, Ms. Robinson, I don't know. I simply reported what I discovered, and that was that Reverend Mack had asked the superintendent to acquire a parliamentarian. But so I never had any discussion with either Reverend Mack nor Dr. Postaway on that.
So how do we follow up on something? Because as a new board, if something is already in progress, I think that it's important for us to know where we need to begin, or is that no longer relevant? Is the Clemson Equity and-
Are you asking this, the Clemson study no longer relevant?
No, I'm sorry that I'm not being clear. An email that was sent out said that the parliamentary for the board was a request of the prior chair based on a recommendation of the Clemson Equity and Inclusion Study. When that recommendation was made, it was based on this study. So is that study no longer relevant so that we don't have to really worry of whether or not we need a parliamentary? Did we satisfy the needs of the Clemson Equity and Inclusion Study?
So we have not engaged with that study for quite some time. The study, I think, was issued in, I think it was in the winter of 2019. It was a presentation made to the school board here in a board meeting in I think it was the winter of 2019. I don't recall the last time the board actually engaged with that study.
So what you're saying is that we have studies and then it doesn't, like, when the study makes recommendation, we don't follow through on it and then close it out. We just let it go.
What I'm saying is that the study was presented to the school board. The school board took certain actions. I don't remember off the top of my head. I don't remember what those actions are right now. And the study has not been participated in. The district has not participated in the study or the recommendations of the study for quite some time. I mean, in my personal history here in the district, well, it's not as long as Ms. Paler. I mean, there's been a number of studies that have been issued, and we've taken actions on some of the recommendations coming out of those studies, but we don't keep the studies, alive for indefinitely.
But do you close it out? That's what I'm asking. So what happens? We spend money on studies and then you take actions on some things and then it goes away. I guess that's what I'm asking because you brought it up in an email.
Well, again, any study that we do is presented to the school board, and the school board takes actions. And so it gives directions to the staff to take action. And so if we're not given directions to do something, we don't do it. So again, in terms of the Clemson study that was issued, 4 years ago, about 4 years ago, there were certain actions that came out of there, but in recent times, there's nothing that's been done with that. And so we from the board standpoint, and so staff hasn't done anything with it.
Oh, when I read that email, my impression from that email was that study was done because of the behavior of the past school board. When that parliamentarian was put into place because of the actions and the behavior of that particular school board. That's why the parliamentarian was put into place.
So the study was done because of a lack of academic achievement by minority students in the district for over a long period of time. That was the impetus for the study. And so there were a set of recommendations that came out of that study. And in the email that I saw, one of those recommendations by the board chair was to hire a parliamentarian. Again, that was not at least in what my research shows, that was not a board action. That was the action by the board chair.
That's correct. I mean, I looked back at those minutes and it was a recommendation from Reverend Mack, but there was no vote taken by the board.
But it was not based on the board's behavior.
The Clemson study was not based on the board's behavior. The Clemson study was based, again, like I
Student
said,
achievement.
on student achievement. I mean, I was here when the Clemson, in fact, I came into the district for the second time when the Clemson study was being inaugurated.
That kind of concludes. I did want to mention one thing, which I forgot, just so you would know. Carol, you
Yeah,
got,
I have a question. Could you also go through like when there's a motion, that you talked about the motion to table, but what about the motion when somebody wants to make a friendly amendment? That's what it seems like. It gets a little confusing, to me.
yeah. Well, a person can make a motion to amend the wording of a main motion. And then there's discussion on that. And it can get confusing because somebody else can make a motion to amend that. So that's when I would advise looking at this sheet very closely because it tells you exactly how to handle that. And I had that happen to me numerous times when I was doing that. And you just kind of you have to keep a list of what motions are pending, and then they prioritize the motions. So
Don't you start with the latest amendment
yeah,
first, and then
right.
it's either yes or no, and then you go to that, and it's yes or no, and then the motion.
Yes. I think your board chair she's gonna know all of that stuff because that's something that is gonna happen frequently. What you normally have to go to a parliamentarian for is something that is unusual, that doesn't happen frequently. So
I just think like we need to know too, because if there's a motion and we want to make an amendment, then we need as other board members to know the proper way to make an amendment. And then if we want to make a friendly amendment, then we need to know that because it's like, we don't want to, at least I don't want to be out of order because I don't know the proper procedure to do that. So that's why I'm asking the question and would appreciate a clarification.
well, every board member is given an opportunity to speak on every motion. So if you want to amend it, you would make a motion to amend, and you would, of course, give the language that you want to insert and where you want it inserted. And that's the importance of having the agenda ahead of time. So you can do that and you can make that motion. And you also need a second. So remember, if you're going to make a motion to amend, you have to have a second before there's discussion on it. And then the chair is going to call for discussion. And some other board member may say, well, I want to amend, that language to like change a word or two or whatever. So it can keep going for a while, especially if something is very contentious, or you just want to get the language right, because it is important in policies to get the language right, because that's going to be governing your procedures in the future. So did I help? Did that help? Or you still got?
That helps, but I think it's, what happens is that if we get in that situation where we're having discussion, then they want to amend it, then they want to change the word, that's when it starts to look like the board doesn't know what it's doing. And, the public may not understand that, hey, we're working through a decision here and we're working through it in front of you. And we're trying to be transparent in how we're thinking. And we don't want you to think that we don't know what we're doing. We're just trying to make something better.
Well, and I think that that's the importance of having the committee as a whole also, because that's when you talk through, because policies should be brought there first. And at that point, that's when you're really discussing, because you're not making motions and you're not taking action on them. So you can talk through things and make recommendations to whoever the author is, or you can go ahead and say, I recommend that we change it to read this, and then you make your notes to that. And because a lot of it is going to be negotiations with the other board members, and you might even want to talk to them in between the committee of the whole and the actual board meeting when things are going to come up. But I don't think, you might feel like you look like it's confusing, but that's the way meetings are. And if you are thinking about what you want to say, you want to get it like you want it. And that's why you have the extra opportunity of the committee of the whole to kind of talk it through at that point. And then, you can work on exactly what you want when you get, if it gets recommended out, then you can be ready to have your motion to amend, or you can make because at that meeting, you're really not gonna amend it, because you can't make a motion and take action. But you can also get your arguments out there, or, where you stand and why you think it should be different. And start thinking about, getting your votes lined up for what you want, which is, what we're seeing going on at a grand scale in Congress right now. They can't get their votes lined up. So that's a big part of it. But I think with having the Cal meeting is a great place to kind of work through, okay, somebody says it needs to be changed. They're bringing a new policy. And most of your policies are going to be amendments to existing policies, I think. So when they come and you don't like, when you see it, when you don't like some of the language and you want to rewrite it, you should be ready to talk about it at the committee of the whole. And then you can get an impression of where that's going to go. And that's your time really to knock it around and try to figure out where you want to go with it.
And whether or not, if it makes the agenda for the board meeting, if you're going to vote for it or not.
Correct.
Then that's why I have a question. So out of the committee of the whole, we bring agenda items to the committee of the whole, and then how are those items then recommended to be on the board agenda? That sounds like a vote to me.
It's a vote, but it's not,
Action.
it's not an action. The chair of the committee of the whole, the committee as a whole will vote to put certain things on the agenda, and the chair presents those to the chair of the committee of a whole, presents those to the chair of the board as the items to be included on the agenda. But the committee as a whole is where you discuss it and you have latitude to go back and forth and exchange ideas about what the issues are. For example, with the motion, how do you want it worded? And someone may not be opposed to changing something in a motion, and you can just get it resolved in the committee before it even gets to the full board for a vote.
So yeah, you would make a motion in the committee. If you didn't like the way it was worded, you wanted to change "the" to "a," for example, and you make a motion to amend to change the word "the" to "a." And you get a second and you get a majority vote, then that's the one that will go. So as the recommendation, now that doesn't mean that somebody's not going to come in when it gets to the board and say, I move that we move it back to "the" rather than "a." So, but you can at least kind of figure out where you're going. And this is also where the majority rules. And if the majority expresses where they are with something, that's kind of the civility part of it too, where you don't keep pounding that, okay, I'm the only one, but I'm right. Okay, it's majority rule. So you got to remember that too. But these are all good questions, and to try to clarify, I think that having the committee of the whole is a great thing to have, because it gives you additional time to think through what you're going to do and what action items you want. And you get to talk about it and hear different perspectives and kind of figure out in your mind what is the best for the school district. What's going to move along the educational plan for the district.
And Carol, I will tell you something that I think will make us sound like we are in the know as much as anything, is for people not to say, I motion that. I move that. Or I want to make a motion and then state it. But don't say, I motion that we, and then whatever, because that is not Robert's Rules of Order or proper wording. And that does make us sound like we don't know what we're doing. That's my 2 cents on that. Use the right language.
This is going to be a learning process for y'all. And it would be for anybody who steps up and runs for public office, because basically every public officer is like city council. They got the same issues that y'all have, county council, the House of Representatives. They all have these same issues. And that's why we do have Robert's Rules, because it does impact the whole governance structure that we've got in place in our state, in our city, our state, our country. And, it's worked pretty well. So I think that's where, and there are little tweaks, because I know committee of the whole, they didn't used to have that. And that's kind of a new tweak, which I think is great, because it does give you that opportunity where you've got friendly exchange of ideas and people express what their opinions are, and you can listen to them, you can agree with them or not agree with them. And that's your prerogative.
And it allows the public an opportunity to hear it as well, and they can
Correct.
chime in to their respective board member to give feedback before, if it does make the board agenda, to give their feedback so that it is necessary.
I agree with you. I think that's the part of the Freedom of Information Act, so that the public knows what you're voting on, what's going on, and the fact that you actually deliberated on it. So, I mean, there's nothing worse than somebody coming in and somebody just says, move we approve, unless it's a real simple thing. So I think that and there will be simple things, luckily. But I think whenever you're dealing with a policy change, for example, I think that's very serious. And I think it's something that you need to consider and, get input from everybody on.
So I pulled up the Clemson study. So let me just say what it says, okay? So we can have clarity on that. There's a section in here on a parliamentarian. So I'm gonna do two things. I'm gonna read a couple of parts of the couple sentences rather of the prologue to say what it was, why the study was done. So first of all, the Charleston County School District fails nearly half of its students. Those students who are already at or above grade level are well served by the district. Those students who are not, are not. In effect, the district is comprised of two parallel school systems. So it goes on and on. So that's really the basis of the study.
Mhm.
And then in the study, there's a series of recommendations. One recommendation is in the section that's labeled make school district governance more efficient, accountable, and credible. And in there, it does have a recommendation that a number of recommendations. Designate a parliamentarian to oversee procedures and conduct that board meetings in accordance with board rules. So it says designate a parliamentarian. Now, so that is in the report. The board that we went back and took a look. The board didn't vote on that. That was a direction from this board chair to the superintendent.
Thank you.
I just wanted to provide one last piece of information that you haven't asked, but I think it's important that you know about. As a board member, you have insurance. So, everyone, as we know, if you're a public figure, you could be open to any kind of lawsuit or legal activity. And so the school district has insurance through the school board's insurance trust, and that protects, as long as you're acting within the scope of your position, you're protected. Now, that doesn't mean you can come in here and bring a gun and shoot somebody. You're not protected for that. So you have to be acting within the scope of your position and that type of thing. But you do have, nobody would run for public office otherwise. So, but you do have that. So I wanted you to feel somewhat comfortable about that. So anything else that you can think of that we can clarify for you? Thank you.
Thank you.
And, if you have a question, we're around. You can contact us and ask us.